All right, we're here on case number D500910, Jensen versus Jensen. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157, present and appearing for Caroline Jensen, who has filed a request for notice of telephonic appearance.
Well, let's see if it's necessary. We all know how telephonic appearances.
I know she really would like to hear because she's...
Well, let me see.
Wait, and then I'd also like to make one housekeeping measure before we start, after you hear about
Can I get an appearance from the opposing counsel?
Joseph Carricelli, 10634, and Sabrina Nilsson.
13-1-5.
On behalf of Shane Jensen, who is present.
Your Honor, we would object today with Shane being allowed to go forward. It would be a violation, clearly, of your court order that disqualifies counsel. Last hearing, I understand, I didn't think now the motion could be fugitive because his new counsel, this counsel should not be recognized for any purpose. He's allowed to file his writ, waited too long, but for today's purpose, I think it would be a clear violation by counsel and the client to violate your court order and continue to come into hearings that have been confirmed for status check for new counsel.
Okay, now, can I respond to that?
Please, Your Honor.
Because, believe it or not, I picked up on the issue you raised. I even ran it by our chief judge because there was a little bit of an administrative issue here. Okay? If Mr. Carcioni and Ms. Dolson were pursuing substantive claims on behalf of their client, I would agree with you wholeheartedly. But there's two reasons why I'm going to disagree with you. Reason number one is they're asserting a collateral issue, okay? Part one. Part two, I did stay the disqualification. I did. I went back in the minutes and I even looked at the video. I had actually stayed the disqualification for 2 weeks.
Yeah.
Okay. Okay. I get all that.
All right.
Okay.
All right. I get it.
And I actually ran it by our chief judge. It's not like I was, saying, hey, maybe this is an issue. Hey, maybe I'll ignore it. I did not ignore it.
For the record, their motion, maybe they can appear on that today as an ancillary issue. However, this status check hearing also consolidated for today's hearing is for, wait, if I may, Your Honor, is on for presentation of his new counsel so that you could go ahead and set the April 2019 motion to reaffirm the October 17 review of support back on track.
What?
So for that issue,
counsel.
Okay, thank you. I just
sit down. What new issue? What new counsel? I don't think there's new counsel yet.
If you look at the decision in order, it said within 2 weeks of the hearing,
I get it.
we would be present with new counsel. That still hasn't happened.
Mr. Carcioni, has anybody else offered to take on the case? Have you approached anyone to take on this case?
No, we're here for a stay so that we can get a decision.
But here's the deal. Mr. Carcioni, this matter was not even taken up on a writ until this week, or last week. And that being the case, here's where I'm going on these narrow issues, and then we can address the status check issue. As to the motion, I will grant a stay on collection of attorney's fees, conditioned specifically on the posting of a bond for the amount of fees awarded.
And he will. Okay,
it needs to be posted so that there's a fund there that your client will be assured of getting.
Your Honor, she owes me $6 grand. You're doing the wrong analysis. The attorney fees is an appeal issue, and the DQ is a writ issue.
It's always interesting when I rule and then everybody keeps going on and arguing with me.
I just didn't get an opportunity to explain that they used the wrong...
Did you consider, Hugh, that there's a brain in this head, and I've considered everything that you want to tell me?
I would
I've
urge the court to allow me oral argument
your claims of hardship. So, in order to make sure there's some protection here, I'm going to require the posting of a bond for the specific amount of the fees. Furthermore, I will order that commencing today, that number will bear interest at the statutory rate. That's as far as I'm going to go on the fees. Now, I'm not done.
At the time of the judgment, not
I am not done. It's my court, not yours. At least for a little while. Second thing, I am lifting the stay on the disqualification. So, if there's anything to be done in this case, pending a decision on the writ, it will need to be handled by a different attorney, because your firm is off the case effective today.
Okay, we request
you still have a writ, that you can take
And we have a right
up.
to request a stay from the Supreme Court now that this court has denied it.
You can ask, alright, well, you didn't ask me for a stay on that, you asked me for a stay on collection of fees.
No, we did. We're requesting a stay on all the proceedings to allow
No,
for a
the
decision.
way you wrote it, it was really requesting a stay on the fees, and I'm denying the stay on disqualification. If you wanna stay on that, you can get that from the Supreme Court.
As long as we have an order from you saying that you're denying that, then we can take it up, because we have to request it.
You're gonna get an order denying that,
Perfect.
okay? And I'm
Thank you.
lifting the stay effective today. What does that mean? Let me finish. Because I still have full jurisdiction over that case. I'm setting motion argument on the pending motions to determine whether I need to set an evidentiary hearing. That's gonna come up in the next 30 days. So, what does that mean? Well, Mr. Caragione, if you think that the Supreme Court's gonna rule in the next 30 days, maybe your client doesn't need new counsel. But I would suggest, since he's coming back in 30 days, and there will likely not be a ruling from the Supreme Court on this issue, I could be wrong, I've been surprised before, your client will need to walk in either pro se or with a new attorney, because I will be taking arguments on the pending issues and determine whether an evidentiary hearing is necessary. I agree with Ms. Vaccarino. Delay does not help the parties. Delay works a hardship on the parties. And remember that if in fact I find that Ms. Vaccarino's client is entitled to child support, it's gonna go back to that date of the motion. Gonna go back really, really far. So your client wants to get this addressed sooner rather than later. But he does not have counsel right now on this case.
But just for the record, he's already offered to pay her the child support back to the date.
Yeah,
We've argued about that. We've argued about that 100 times. She
It's
says
in
there's
my
no
reply.
offer.
I would stipulate to a stipulated amount, reserving jurisdiction to your honor that does have a brain
Okay,
in her
we
head.
save that for the
But you know what?
arguments. But we,
They can pay 23 grand,
we
but not
say-
8 grand stipulated in fees.
Okay,
27
how many
grand
times do you
bond.
want me to say we're gonna argue that
Because
issue?
he's just
That he's going to come in with new counsel. Now, whether he needs new counsel for a short period of time or a long period of time, I don't know. And I think, as I said to you, Mr. Caragione, before, I think you and the members of your firm know some people you can reach out to so that he has counsel when he comes in. And I will require both parties to appear, because I will be setting an evidentiary hearing, and I want to make sure that we don't have some issues on dates. Because both parties have jobs that are incredibly demanding, and I'm going to try and set an evidentiary hearing if one is necessary, if it isn't resolved, to accommodate that. I don't want people to lose their jobs or even, have any disciplinary problems.
Your Honor, for the...
And I'm not unmindful of the fact that the plaintiff could not be here because of the demands of her job. I mean, I don't know that the U.S. Air Force cares that much about my courtroom schedule.
She's no longer with the Air Force. She retired,
She did not retire.
as our understanding. But
No,
anyhow,
she didn't retire
would
yet.
you
You saw
mind-
her FDA. That's another thing, Your Honor. He keeps throwing this stuff in,
Okay,
but I would like
we're
a
done.
ruling from
We're
you on
done.
FDA.
I
We're
just
done.
want to ask one question.
I
Would you
need
mind
rulings.
issuing a written order today denying the request to stay the proceedings or the disqualification so we can take
Except as a
emergency-
part, it pertains to the attorney's
Yes.
fee award, but that is requires the posting of a bond for the total amount of the fees that I awarded.
Right.
I'm further ordering that those fees will commence to incur interest at the statutory rate.
From the judgment. The statute says
She
from the
said from
judgment
today.
forward, Your Honor. I just don't wanna have any more.
As of the date of the judgment,
Thank
yes.
you. Okay, I just wanna be clear
Um,
because then they'll
but
pick up
the-
on
but
that and need an
I'm requiring the bond in the base amount of the award,
And you will be posting that.
so there's a sum certain.
Do we post that with the clerk of the court here?
Your Honor, may
I can't hear two
Sorry,
people at
Sorry,
once.
I'm just asking, do we post that with the clerk of the
No,
court?
I was actually engaged
May I be-
in a conversation with Mr.
I'm sorry, I have to sit down.
Caragione. Now, what did you
Do we,
want to
post
say?
that with the clerk of the court here? Do
What?
we pay that to the clerk of the court here to post the bond?
However you wanna do it, but I would prefer clerk of the court, yeah.
Okay, then we'll do that today. And then she had already, it looked like from her billing entry, she tried to execute a writ on the attorney's fees, so I don't know if she's collected anything or if she did anything, but, if she could disclose that because he doesn't wanna double post the
Why don't
money.
you ask Ms. Vaccarino yourself? Out of court, not here. I'm not gonna listen to you two bicker. I get bored with that.
No, I'm just saying that she can't double collect the same monies that we're posting as a bond.
And I don't know that. And so that's a conversation you have with Ms. Vaccarino. I'm not gonna require representation in my court today.
And we appreciate the written order so we can file our emergency motion with the court. Do you want
They
us to
can
prepare it or will the court?
And enter it today without a problem, yeah.
Who's preparing?
I would
I'd
think
be
if
happy
they're,
to prepare it.
if you're granting it,
In
but
fact-
I would like to, please, Your Honor, I know your order, I would say one
She
thing.
interrupted me.
If I say one,
I'm just asking one question.
alright, I'll sit down as I can have a fair amount of time to just briefly respond for the appellate record,
All right,
apparently.
Mr. Carasoni, now that you've interrupted Ms. Vaccarino, make it brief.
Okay, I don't wanna have this delay that, you know, the order isn't approved. I'm gonna make it very simple that.
Be a lawyer,
Yes.
do your job.
And can I direct submit it to the court, copied upon Ms. Reno?
No
It's gonna
objection.
be too long.
No.
Okay, good, no objection.
No,
she
I'm
said.
requiring submission to Ms. Vaccarino.
Fine.
So-
I'll look at it right away since it's extremely short, I won't
Okay.
wait the 10 days.
No,
Agreed.
we needed to file our motion with the Supreme
Well,
Court.
I know, so
Thank
Ms.
you.
Vaccarino's already represented, she'll get back to you right away.
Perfect, thank you, Your Honor.
Okay, now Ms.
Just briefly,
Vaccarino.
Your Honor, with respect to the court's ruling, there are two issues here that they picked up on in their reply that was filed late. First and foremost, you're waiving the requirement of filing an FDF under the 16.1 rule and this rule because if he's able to post 28 Gs, but he can't pay starting next month 16 a month, 100 a month,
How many times have you appeared in my court, Ms. Vaccarino?
I'm just making.
I have,
We have
I,
a big disagreement on
you know what?
Webster's dictionary analysis of the
I
FDF
have an
rule, but I've
over
heard you before.
15-year-old reputation for being a stickler when it comes to financial
So
disclosure.
it
form.
should have been filed. And
Ms.
I'm-
Vaccarino, why are you talking over me?
Okay. I just wasn't finished.
And so, to the extent that defendants seek some kind of relief without submitting a proper financial disclosure form prior to our new hearing, he's gonna have a problem with me, cause there'll be a sanction. Okay, so, I want his financial disclosure form filed no later than a week from today.
By his
Served
own-
on Ms. Vaccarino,
Well,
so that we have
Yeah.
Well,
We'd have to file it on his.
Your Honor, they're disqualified. You made your
No,
order.
no. He's gonna have to file it through new counsel, which is why I'm giving him a week. Cause I don't think he needs more than a week to have a new counsel appear in the case and file an FDF. Okay? No, you can't file it for him, absolutely not.
So my client owes me $6,000. She owed $30,000 to her employer. May have to defend a writ, and you too, and I have to be present in 30 days. So the hardship, and Finn gets $300 a month instead of $1,600 with the new writ.
Every time
Wait,
you make a
if I
decision,
may,
she
for
just
the
keeps
record.
arguing.
So what I'm saying is, I think there is.
What's our new hearing date for,
We have-
Thank you.
cause
Would you
I'm
defer on the
saying,
issue of attorney's
counsel,
fees?
save it for next time.
Will you defer on our
She just
counter
keeps
motion?
making requests, Your Honor.
What?
How long do you think?
30 days.
No, I mean for the length of time of the hearing.
What?
The next,
For the length of time of
Oh,
the hearing.
put them on at 11.
Okay.
Luckily, I have a short 10 o'clock calendar. But for next time, it's 11, because I know somehow it's just going to go on and on and on.
Okay. Okay, do you wanna do a push?
Yeah.
Okay, then let's do this on. We could do, Wednesday, February 26th at 11?
I can do that. Thank you, Your Honor. And so our counter motion for fees is deferred till the next hearing.
Everything is
After you looked at the FDF. You did rule on their motion, but our
They all
counter
have
motion,
motions pending.
if I may.
Counselor deferred. We're
Thank
doing
you.
everything
My
else
counter
in
motion from today is
February.
deferred, but you decided
Okay.
their motion that's pending, all right?
And by the way, I
Thank you, Your Honor.
granted it in part and denied that in part, so keep that in mind,
I
counsel.
I understand, Your Honor.
And if I thought that you could, I mean, I don't know if you're gonna get a stay out of the Supreme Court. I honestly don't know how they're gonna view this case. You know, it
Yeah.
was a very complex issue for me, and I would imagine for them it might well be too, because you know, it was a close issue. It was.
That's why you took testimony. The Yellow Cab case says you have to have a manifest abuse of discretion. The unreported case from
She's
2000.
arguing that.
All right,
We can argue all this in the Supreme Court.
I hear it, Your Honor, but
Tell you
we're
what, Ms.
prepared
Vaccarino,
to-
save all that for the Supreme Court.
I hope not. I hope it's denied without.
I don't know what they're gonna
Thank you,
do.
Your Honor.
I don't, but in the
Horrible.
meantime, your client needs a new attorney.
Thank
who will assist him in preparing his financial disclosure form, which is due in a week.
Okay.
And then new counsel will have to appear on his behalf, unless he wants to come in pro se. I don't think so.
Appreciate the
Thank you,
personal.
Loretta.